Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video, and I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a family law firm out in the Worcester area, and she is extremely intelligent on family law and strategies to help you get the best outcome for your case. So today I want to welcome Nicole. We are going to be talking about something very interesting and something we haven't covered before. And it's going to be on witnesses and trial exhibits. So this is going to be all new to me. Welcome to the show, Nicole. Thank you so much for joining us.
Thanks for having me.
So why don't you tell us a little bit about, witnesses that we have to call? Do you have to tell the other side which witnesses? Or can there be surprise witnesses just like on TV?
And that's exactly what I always say. It's not like it's on TV, people. This is real life. We don't get to surprise the other party with witnesses. It just doesn't magically flow out and we're going to have that one witness that's going to tell you everything about your case. Nope, doesn't happen. So you're going to have to share with both the judge and the other party who your witnesses are going to be, and the judge may even ask you as to what that person may testify to generically, and you'll have to give them that information as well.
That's too bad. That means there's less drama in court than we all think there is. Do you have to have a limit of the number of witnesses you're allowed to have? Because I know people might go a little crazy and have everybody they know up there.
All too often people will do that. And that's another reason why the judge is going to want to know beforehand who the witnesses are going to be, and more importantly, what they're going to testify to. If you're going to have 5 people in the household testify that Erica is the best mother in the entire universe and she can't do anything wrong, the judge already heard it after one person. Why are we going to have 5 people testify? So the judge doesn't want to hear the same thing. Now, if we're talking about a specific instance, let's say, for example, an accident that happened, the judge may want to hear from different people because they might know different parts of it. The accident happened on this day and this person was there and was in the car with me when the accident happened. Oh, the next person is going to testify as to when I was at the hospital and what happened there. And then the third person is going to testify as to what happened when I got home from the hospital. So if they're going to tell different parts of the story as to getting along with how things are moving in your case, then yes, you can have multiple people testify. But the judge does not want to hear more than one person testify about the same thing, because generally speaking, the party, the plaintiff or defendant, is going to also testify. So now we've got one additional witness. We don't need to hear for a third time. You're just wasting the court's time. You're wasting the court's resources. And tell me why I should put this witness on the stand is basically what's going to end up happening.
And that makes sense. There's only so much time in a day, and the courts are so busy, especially right now. Can you tell us, what are the typical things that witnesses testify to?
They're going to testify as to what they know. They're not going to testify as, well, Jane told me that Erica said. No, that's not going to be permitted. But I can say that I saw Erica do this. They can say, Erica told me this. I had this document and this is what my signature looks like. So they can testify as to what they know firsthand, not something that they didn't see. They can't speculate as to whether or not, that's your signature that that they don't even know you on, unless they're an expert. They're an expert in handwriting, sure. But short of that, they're not going to be able to testify to certain things that they don't have firsthand knowledge of.
I mean, and that's interesting. And I'm sure that lots of them will just try to say what they think they know as opposed to what they actually saw or what they actually know. So what is it that is not permissible for these witnesses to testify?
Well, there's a million of them. And any good attorney is going to be able to know exactly what they are when they come up. But again, it's going to be when again you don't have firsthand knowledge, when you're you're looking at a document that's signed by a third party that's not there. That's what you call a hearsay document. So there are certain things that you're only going to be able to testify to. Again, that's what you firsthand know, what you witnessed, what you saw, what you heard. What impact do you have on this particular case? What can you tell the judge that's important that you personally can articulate? So a lot of that, again, he said, she said from the third parties, nope, not coming in. Maybe we can talk about, well, we were at a joint party and all 5 people saw this, but we all saw it from different angles. Maybe, but you're all going to have different versions. So again, the question comes down to who the judge is going to believe.
Well, this is an interesting question. Who do they typically believe? Like, what are some of the characteristics of a good witness?
Well, I think, judges are going to know who's telling the truth. You kind of have that instinct. It's their demeanor, it's their cockiness, it's their attitude, it's their appearance. Are you going to come across as somebody that has something memorized? So you have those people that really go, I know this information and I'm just going to reiterate it just how my attorney told me. We can see that. A good attorney is going to prep you. A good attorney is never going to tell you, memorize this, because then you're going to look like, hey, I memorized this and I'm really just telling you the story because my attorney told me to tell you. Like, come on, guys. The judge is very intelligent, has lots of schooling, has lots of information under their belt. They see this day in and day out. So really, again, when you go, I don't recall, the party asked me, I don't recall, I don't know, I don't remember. But then when I ask you a question, you have diarrhea of the mouth and you're telling me everything. Well, how are you so selective in your memory? So again, those are the things that really are going to kind of go, I don't believe you. So all of those things are going to have an impact as to whether or not the judge believes you or not. Again, it comes down to being prepared, having your witness testify, prepping them accordingly, having them know what they're going to be looking at, and then try to prepare them for what the other side may ask them for questions. Because again, a good preparation is really going to at least let the judge know you've taken the time to really think about this case.
About the exhibits. Now, when I think of exhibits, I think like a lot of people, we just think immediately of murder trials that are on TV where there's like all of this evidence that happens to be a murder weapon. And it's not so simple with family law. You have exhibits, but it may not be something that is so earth-shattering to see. Can you give us some ideas about what the exhibits are and how they're used?
Yeah, in family law, as in most cases, you're not going to have that smoking gun. You're not going to have those documents. You're not going to have the bloody rags. You're not. What you're going to have is documents. Exhibits 9 times out of 10 are going to be documents. Sometimes they're videos, but they're going to be usually in paper form, and it could be bank statements. It could be, arrest records. It could be, deeds. It's going to be something that's particular to your case to show the judge that, hey, look, there was, at this time, we withdrew $20,000 and then it magically disappeared. But at that time, they also bought a car for $20,000. Judge, go figure. And sometimes, that's our smoking gun, if you will. That's how we articulate to the judge that, look, follow the paper trail, Your Honor. You can see where the money went. You can see what happened. You can see the facts of this case. So it's really painting a picture for a judge. Sometimes, again, it is that video where, there's obviously some kind of altercation or verbal communication between parties. We want to have that submitted to the court. Sometimes it's just a condition of the home or the way a house was left. So it could be a lot of different things. It would be photographs as well, but it's going to be most likely in paper format or some kind of media that shows this is how we need to tell the judge why it's important to our story and what impact it has.
Do you have to share the exhibits and the information with the other side before the trial or the court dates?
Again, we go back to it's not TV. The simple answer is yes. Now, there's exceptions to every rule, but the simple answer is yes, you have to share it. Yes, you actually have to get the other party the records timely. They have the right to object to those documents, or they have the right to say, yep, I have no objection to them. But no, we don't go in and we don't just say, yes, here, Your Honor, here's our smoking gun, again, no matter what it is, and we're going to show it. That's on TV. We're in real life, and we don't get to do that in America.
I mean, that is funny because it's always like they're out there trying to still do investigative work and then run to the courthouse and throw it there before the final decision is made. But you didn't see this, did you? And well, they're actually alive. So it's a little sad to hear that it's not that exciting in court for you. But how is it that the judge sees the special exhibits?
I think, again, it goes back to you're laying that nice little foundation for everyone, and you're putting the puzzle pieces together for the judge. The judge isn't going to look through 2,500 pages. The judge is going to say, okay, counsel, we're on which page of the exhibit? We're on exhibit 11, section 350. Okay, and we're looking at paragraph 5. I'm going to point out to the judge exactly where I want the judge to look. And then I'm going to either have the other party read it, or I'm going to say, doesn't it say blah, blah, blah? And then the witness is going to testify to it. So we're going to point exactly what we want the judge to see. And then the very next question is going to be, okay, now if you could turn to the next document, then doesn't it say this, this, and this? Oh, yeah, it does. Okay, so which two of those statements is correct? So that's our smoking gun. That's how we present the evidence, is going, something here doesn't sound right, judge. Tell me why it doesn't sound right. Maybe it's because you shouldn't believe that witness on the stand. And that's really how we get our point across. Now, again, is it always a smoking gun? Of course not. But our job as an attorney is to point out the issues that go, just doesn't sound exactly right, judge. And we let the judge make that conclusion. So there's no real smoking gun for the most part, but the reality is we have those documents that the judge scratches his head and goes, yeah, I don't believe this portion of the witness's testimony, or I absolutely believe the portion because this document solidifies that.
So I'm sure that each document and each exhibit is going to make one of the parties involved look bad. And I mean, that's the point of it. You're trying to make your point, you're trying to make your case, and you're going to dig up the worst possible things about your opponent and vice versa. So I'm sure that there's plenty of times when a document or an exhibit is not going to see the light of day because the other side doesn't want that to be shown. And what happens if they don't want it to be shown? Do you have a course of action where you can prove that this is the best thing to show the judge?
Depends, you may. The reality is you're going to know in advance because, again, you showed it to opposing counsel and they already said, I'm objecting to that. If you're smart, you're going to ask for a reason for their objection. Once you know what their reason is, maybe you can overcome that objection. So if it is, this is a hearsay document, okay, then that means I need to either get certified copies or put the author of this letter or document on the stand. How do I get around that? So is it something that is, your diary? Well, then you're going to be able to testify to that, but you might have to expose all of your diary to the rest of the world. So you may not want to do that. So there's certain things that we're going to weigh pros and cons on both of those and say, what do we need to do to A, get that in? B, can we get that in another means? Maybe it's just your testimony and we have to rely on your testimony alone because we have no alternative to get the documents in and the judge has already said no. Or could it be something that, again, we can do something to get that document in? So it really kind of depends on the document and the reason for not wanting it in.
So do all of the exhibits get seen by the judge that are approved by everyone?
If they're approved by the court or the opposing party, then yes, the judge will be able to look at all of them. Again, if you hand the judge a stack of bank statements for the last 3 years, there's no judge in the world that's going to look through each page and try to figure out what it is that you possibly wanted to show them. The judge is going to go, counsel, why are you not putting in the 1 page or the 1 page statement of the document that you want to show? And certain, you as the other party might go, no, I want them all in. So again, that's the question is, are they going to look at all of it? Yes. Do they have the right to look at all of it? Yes. Are they going to look at it in any real detail if it has a voluminous thing that really doesn't matter and you haven't pointed to that smoking gun? Probably not. I'm not the judge, but that's my guess. Because I've had judges sit there and say, counsel, what paragraph are you asking me to look at? This is a 50-page document. And you better be able to give them the page and the paragraph and specifically the sentence. Because otherwise they're going to review it in chambers later on. They're not going to necessarily review it right then when the witness is on the stand. And if you don't get it somehow earmarked in their mind, they're not going to go back to it and go, what was that? And they're certainly not going to listen to the transcript that says, counsel had mentioned an exhibit 50 line. What was that? They're not going to listen to the transcript for that one sentence.
So you've been doing this for a number of years. I'm just curious, after listening to all of this, what in your opinion is the best evidence and exhibit and witness? Like, do you have like favorite ones that tend to work over other ones? And I know all of this is kind of on a case-by-case basis, but there are certain documents that might work better than others, and certain witnesses.
I think, ideally, if you're dealing with a family law case, if I could get non-family member witnesses, those are the most beneficial. We know that your mother is going to say that you're a saint. I get it. We all know that. There's a little bit of bias there. No matter what you say, there is. So, give me the neighbor. Don't give me your sister. Give me somebody else that's a non-family member that can tell me the exact same thing. Now, sometimes there isn't somebody to tell the exact same thing. But an ideal witness is going to be somebody else other than the parties that can testify to something that's going to be beneficial to us or negative to the other side, obviously. But that's really what we're going to look for. In terms of exhibits, again, it really depends on looking at each detail on that piece of paper and go, let me see, that says, okay, what are those things that are really going to solidify it? Because sometimes it just gets, counsel, you have 70 exhibits here and the judge doesn't want to hear it. Give me the facts, give me the information, give me the exhibits. So what can we narrow down? Do we need to give them the 100-page document? No, let's give them the 2-page document. Again, we might not be able to get it in without the other party agreeing to that, but see what we can do. The more tailored documentation we can give to the judge, the better off we are, because it's more inclined that the judge is going to be able to look at it, see exactly what it says and go, yeah, I get it. It correlates perfectly with what you just testified to. So concise, I think, is good. I think, you want to have those concise documents, that concise witness. You want to have the witnesses that are properly prepped. You really want to make sure that they can articulate things. And it's not that they have to be intelligent or have, the law degrees or anything of that nature, but just be able to articulate exactly what you're looking for. And do it in such a way that, again, they're not going to be hostile. When you have that person that is a neighbor, but they also think your ex is a scumbag, it's probably going to come across that way. So again, when the other party's asking you questions and you're going, and you're getting in their face, now the judge is going, wait a minute, maybe you're not a good witness. So you really have to kind of look at, well, how much are you really neutral? Or do you really kind of hate this other person and now I may not believe you as much.
I mean, and that is really interesting. And I know that you and I actually witnessed something like this in the court one time. And, just the difference between having an attorney speak for you, being quiet and respectful, and just answering the questions. When the judge is speaking to you directly, just being concise with your answers and as without emotion as much as you possibly can, because it's just, it doesn't show well. I mean, versus the woman that we were looking at who like had her finger in the air and was trying to bring up past cheating instances, which the court does not care about, and just like it just didn't show well. You could just see very clearly between the two parties who was coming across better with the judge.
Absolutely. I think it's one of those things that, if you just go and sit in the courtroom for a day, you'll know that even though the judge is going to take all the matters under advisement, you're probably not going to know a decision. You're going to start formulating opinions about these parties. I just listened to this whole story for 10 minutes, and this is why I believe them. Why do I believe them? Because of how they presented. So it's really important. And like I said, anybody that can walk in the courtroom and listen to that, you're going to come out with the same expression, go, oh my God, it really is true.
Well, this has been very interesting, and we really appreciate your time today. I mean, this is something new that we haven't talked about, that it really does make a big difference in your case. And so I would absolutely suggest to anybody out there, if you are heading to family court for any reason, please give Attorney Nicole Reeves Lavallee and her team a call. They have the best strategies to help you come out with the best outcomes for your family and your situation. So give them a call. Thank you so much for coming on the show today, Nicole.
Thanks for having me.
And thanks to everyone out there for watching. We will see you again next week.